Hello, everyone, and welcome to today's webinar. I am Michael Urch. I'm a Senior Wealth Manager here at 360 Financial. And the main question in front of us today is, do I need a trust or not? And this is the first in several webinars that we'll be having on estate planning. And so do look out for other opportunities for us to talk through some estate planning items. And as a financial planner, I'm excited about this topic because it really gets into wealth transfer and taking care of your family, which we think is one of the most important things for our clients here at 360. Today, we've got a great guest panel. For topics such as this, it's good to have a team of experts that you're working with. And so on our panel today, we have Andy Lerner. He's an attorney at law, and he has a wealth of experience in wills, trusts, guardianships, conservatorships, and probate. And he joins us with help on those items. Joe Rapacki, CPA, we believe will be joining shortly. He's having a little bit of technical difficulties, and he's got a lot of experience with taxation and has a deep understanding of the intricacies of how tax laws impact things such as estate planning. We also have Mike Rogers, AIF here. He is the president and founder of 360 Financial, and Mike has a passion for enriching lives, so much so that that is our core mission here at 360 Financial, to enrich lives. And we also have Brian Bonsack, who joins us from our Elk River office. He's a senior vice president of 360 Financial, financial advisor and managing principal of the Elk River office. And Brian brings some specialties in insurance, life insurance, long-term care, and other insurance as well. And so we're excited to have everyone on the panel here today and to consider the question of, should you consider a trust?
Great, thanks, Michael. I'll take it over from here for a little bit. Then we're going to bring Andy in, and the part of the conversation that I would like to have today is an actual conversation. So, there's you can put into the chat function if you have any questions. You can put questions in here. We're going to leave time at the end for questions, especially, but even on an ongoing basis, if there's some things that we can answer, take advantage of this panel. If you got a lot of knowledge here, and it's great to have Andy join us and to be part of the 360 team on this educational webinar. We know estate planning is one of the crucial elements that our clients face, and by giving more education around it, we're able to help our clients do a few things. First of all, is protect their families. I've been doing this for a long time. I've seen families that have good estate plans, and I've seen families that don't. And I will tell you, if you want to protect your family, the best way to do so to keep the conflicts down, and Andy can probably give you some stories about that, is to have a good estate plan. Have it well documented what your intentions are and how you plan on carrying those intentions out and what you want from the future generations. And that will also protect your wealth. And, and why it's so important to protect our wealth and our family, of course, is, on the probate side, it can get very expensive to go through that process. It doesn't always have to be. And Andy will do a nice job explaining what probate looks like and what it actually is versus what it isn't. But it also protects against creditors, families that may be facing a divorce, or blended families. We have a whole program coming up on that issue specifically. And then the tax piece of it, which is right in Joe's wheelhouse. And Joe, as most of you know, is our CPA partner. And we created that a couple of years ago. So it gives us the tax preparation and the tax strategy, aligning with the wealth management, aligning today with estate planning. So it all kind of falls in together. And this protection for your family is another aspect that's very, very important. Is how do we keep everything private and your distribution of your assets as efficient as possible? And we do that again through better estate planning. So I'm gonna ask Andy to talk a little bit about the history of estate taxes, because he finds this very, very interesting. I do too, but Andy, if you'd like to just give us a little bit of history on it, that'd be terrific.
Yeah, thanks, Mike. I'm glad to be here and happy to share some of these things that I think are useful to some people, although they might be kind of boring to others. I do get a little excited about the estate tax history. So uh, a confession to start off.
Yeah.
No, the estate tax is different from all the other taxes that we're used to, right? It's not the income tax, it's not the sales tax, it's not the property tax, it's the estate tax. Or if you don't like it, it's the death tax. But it's been around a long time in this country since 1916, and it's had lots of different changes over the years. But in the last 30 years, it's been particularly interesting. So the taxable event is when someone passes away and leaves wealth to another person who's still living, a lot of times one generation to the next. And the tax only kicks in when an estate rises to a certain value threshold. And one of the, I guess, notable things historically is the changes in that threshold. Not only that, but also the changes in the taxable rate. But just to quickly illustrate it for our purposes today, in the late 1990s, the federal estate tax kicked in at about $650,000. And today, that number is north of $13 million. And there's a lot of legislation and a lot of law changes that happened over the years that brought us from there to where we sit now, but we're on the cusp of another change, which we can talk about in a moment. But from a planning perspective, the estate tax has been around a long time, but the numbers and the thresholds change. And what an individual has to do in regards to the estate tax is to pause and ask, what is the tax today? And what's in my taxable estate? And is there any exposure and is there anything to be done about it? I just told you a little bit about the federal estate tax. Minnesota also has its own state level estate tax. And the threshold in Minnesota also changes like the federal, but it's different. The Minnesota exemption in the late 90s was lockstep with the federal law, and that's changed in recent years. So even though the federal exemption is north of $13 million, Minnesota's number is $3 million. As soon as an estate approaches that threshold, you got to look at that from a planning perspective. So just as a quick glimpse and context for the estate tax, that's kind of what it is. It's its own thing. It doesn't apply year after year. It's only this limited event, and it applies a little bit differently. And it's very fact specific, depending on the year, whether we're looking at the federal or the state tax, and whether, the individual's estate bumps into those thresholds or not. So I hope that's helpful for an introduction, at least for today's purposes.
It is, Andy. It's interesting. I mean, how it ebbs and flows. People don't realize that, I don't think. I mean, there was one year, and we joked about it, you and I recently, where there was unlimited amount, of exemption. So there was no federal estate tax. So Congress couldn't come to an agreement. What year was that? Do you remember offhand?
Yeah, that's 2010, just for 1 year only.
Yep. And who passed away in 2010? That was kind of famous for this.
Yeah, George Steinbrenner, the owner of the Yankees. And the federal government, I figured, missed out on about $500 million of estate taxes because of that.
Yep.
Yes, in that case, timely death from a tax perspective.
Yeah, lucky George, right? That was, from the perspective of, now it looks like it's going to reset to a much lower limit than we're at now, but we'll get to that in a little bit. So, the point is the estate tax has been around at the federal level for years, and here in Minnesota, we do have an estate tax that we have to be concerned about on our planning. Whole different note is we do have a webinar that we do about once a year that's on changing residency. And that would be another program that might be of interest to some people on this education webinar today. But we won't go into that today. We'll talk about the current situation and what we have. So, one of the, and this slide basically is something that, Mike and or Michael and I can kind of go through, but this is really just looking at what are we first talking about when we talk about an estate. What is that? And so what's the most important thing, one of the most important steps that we take when we build our life wealth plans for our clients is a personal financial statement. And so what we're doing there is just creating what is your net worth, because that is what we're talking about, is everything that you own minus your liabilities. What you owe is your net worth. Okay. And so the very first step to do a good estate plan is to know what we're working with as far as the net worth. If we don't know that, then we're not, going to be able to have a good outcome. And so, what we will typically do is build a flow chart with our clients that will show who owns what, especially if it's a married couple. Sometimes one person owns a certain property, another person owns a different property. What's in joint name, the joint tenants or joint with rights of survivorships, and then running through some basic, potential for taxes that could be incurred on this estate. But it all starts with, we need to know what your financial assets are. Over on the right-hand side of the page, all your retirement assets, your personal property, at least a value, somewhat of a close valuation. You don't have to go out and get, values on your cars, but we can look that up fairly quickly and come up with a reasonable number. The big one's home and real estate values. And sometimes, like today, we had a conversation this morning with a client that owns a farm, in addition to, as a business interest, as an investment. And the land of that, the value of that land has increased substantially over the last dozen years. And so it was time to update the estate plan and the valuation. And that was part of what we covered in today's meeting with that client. And then don't forget about the life insurance and the death benefits. If that's not properly titled, and we'll talk about that in a minute, that also goes into your estate. So if you have a couple $1 million of life insurance that is there for maybe for paying estate taxes, that's something that you want to consider. And of course, any debts that are outstanding go against this life, net worth statement. Boom.
Yeah, and so if you double click on that estate for Joe's, that's this next slide here, and that is 3.56 million. And then the next slide, we break it out a little bit by those different categories. And as Mike just mentioned, that life insurance isn't generally on a net worth statement because it doesn't have a value until the time of death. And that's one of the main differences that we see with your estate value versus your net worth. And it's really important to understand that that's incorporated in the picture.
And Brian, from your expertise of managing our Elk River office and being our risk kind of analyst and specialist, you see this as well, I'm sure, especially for new potential clients coming in.
Exactly, both from a death benefit, but I think you mentioned earlier about liquidity. Life insurance have quick liquidity to go ahead and pay for those final expenses or some estate taxes that are due, giving the family a lot more flexibility than trying to sell a piece of real estate. Obviously, if somebody would have died during a downturn in a real estate market, maybe not be a great time to sell in real estate, but having life insurance to help the family settle the, estate taxes would be a great tool to have. So we do talk a lot about that with clients that have that exposure.
Yeah. Yeah, and that's especially important if you're trying to leave a legacy of these assets around, to the next generation, isn't it?
Yep.
Yeah. So that's really what we're first targeting. The very first thing of our life wealth plans, or you need to be doing on your own, either with your tax professional or just, with a spreadsheet, is try to figure out, where do I stand? Because if we know where we stand, now we can benchmark where you stand against the estate rules to try to minimize, potential tax consequences. So, Andy, maybe what you can do, here in the step 2, after we've done this net worth statement, is just explain to everybody kind of, what is probate? Because that word seems to be scary to people.
That's right. I usually hear people tell me they need to avoid probate, but they're not sure why, but it's really bad, right?
Yeah. Yes.
So yeah, well, it's good to be clear about that. So first of all, the inclusion of death benefit in this calculation is critical. So I'm glad you guys brought that up, because I bump into that all the time with clients who say, oh yeah, we're not in that neighborhood as far as value. And then we start putting it on the table and they think, oh, right, there is some exposure there. So that's an important piece. Regarding probate and not probate, first thing I'll say about that is, regardless of whether an estate needs to be administered involving the court through probate or not, has no bearing on estate tax exposure. So whether something goes through the court for probate administration or whether it goes directly to a named beneficiary because of a trust-based plan or a beneficiary designation, those things are not consequential to the calculation of the overall estate to figure out whether or not there's going to be tax exposure. However, when you are doing some estate planning and you're thinking about how the estate's going to be administered, there are options. And one of the options is by using things like beneficiary designations or the use of a revocable trust, which we'll talk more about today, of course, the topic of the day. And those things have the effect of eliminating the need for the court's involvement in the administration of an estate. And just quickly how that works. If someone hasn't done that kind of planning and they own things, those things are titled in their own name. If that person then passes away, we have a practical problem because that person is now deceased. They're gone. So if I own a house and my name is on the title to that house, and then I pass away, I no longer am available to sign a transfer deed. What do? The answer is we have to go to the court to give somebody, the representative of my estate, the legal authority to be able to deal with it, right? So that is the practical, purpose for probate, is to solve that practical problem of someone's name being on the title to an asset after they pass away. So to avoid the need for probate, to avoid the court's involvement, you can either use a beneficiary designation on certain assets to make sure that asset goes directly to a named beneficiary, because then we don't have that practical problem. We know who gets it. There's a beneficiary named. Or if there's an asset that doesn't easily receive a beneficiary designation, or if you've maybe got several beneficiaries in different proportions with different considerations, a beneficiary designation might not be the right tool. And a trust can step in as an alternative of a way to create an administration of an estate without the court's involvement and with your customized plans. And just quickly how that works when someone, am I getting ahead of myself? So are we talking about how trust work yet? I don't want to jump.
Well, I think we're going to get into that obviously,
Okay,
but I think the very first thing that you answered, for the participants here on the webinar is what does probate process look
Sure.
like? And sometimes I describe it as, and I know this is simplistic, and as an attorney that specializes in this area, you probably have a lot more background information, but basically it's going to a judge, into a court setting. You hire an attorney like Andy or somebody else, represents the estate, and the judge looks over, this probate process. And we all know that means it probably isn't very quick. And so maybe from that standpoint, how long does this process take where a judge or somebody in the court is actually looking over these assets to determine what the heck should happen to them?
Yeah, of course, the answer is always it depends.
Yeah.
But to be succinct, in most cases, if everything goes well and there's not arguments and disputes and things go smoothly, I usually say it's 9 to 12 months of time, typically. And maybe, $3,000 to $5,000 a cost. And that's the baseline if everything goes perfectly. And as soon as there are complications or disputes or ambiguities that need to be solved, the time and cost estimate can increase upwards, and in some cases rapidly. Now, those really high, long, drawn out, matters, they're more of the anomaly. That's not typical. But it's a minimum of, about a year of time and at least several $1,000s.
Yep. Yeah, that sounds, I've heard numbers higher than several thousand. So I think it seems like complications typically come up, and it's really, I mean, how about if you pass away without even a will?
Yeah.
Then what?
We still go through probate, whether or not you have a will. Without a will, though, we have less direction from the decedent, right? So you don't get to speak into the situation. You're just left to Minnesota's default rules, which for some people might be okay. But you don't get to speak into it and customize it. You don't get to choose who's going to be in charge. We still have to walk out the process, and it can take a little bit longer because of the ambiguities as a result. So the will is nice compared to no will, but both of them still require the process.
Yep. Yeah. And I've seen where, people pass away without a will. Let's use Prince as an example here, and what a mess that creates for the entire family, and how heirs kind of pop out of nowhere, rightfully or not, no judgment there, but, saying that they should get a piece of that estate, and it's not just unusual situation where famous people sometime, like Elvis Presley didn't have a will, if I recall correctly, and Prince didn't have a will, but lots of times individuals, and that just bogs down the process too. So the very first step in this kind of probate process, we'll get into the trust part of it, is kind of looking at those wills, isn't it?
Yeah, that's right. And
Yeah.
I guess one other thing quickly about probate too is that it does create a public record. And I was thinking of that when you're talking about, Prince in particular, who was famously private and hated lawyers. I don't know what was wrong with him. He hated lawyers, were great. But as a result, though, his estate, of course, is an open book. You can log in and take a look at it, which would have been horrible from his perspective, I imagine.
Mhm. Yeah, yeah. So if we look at kind of this next, as we move on towards trust, maybe you could spend a little time, Andy, just I guess demystifying
Yeah.
trust. What's a trust? And maybe you start with what's a will. I think most people kind of understand that, but what's a trust?
Yeah, yeah. So a trust and a will are very similar, and I'm talking about a particular kind of trust right now. I'm talking about a revocable trust and a particular kind of revocable trust that's known as a revocable living trust, right? Revocable just means that whoever creates this entity, this trust, has total control over it. It can be amended, revoked, changed. It's very fluid. Living means that you create this trust during your lifetime. So a trust, I mean, when we write it down, it's a piece of paper is what it is, but it actually sets up a legal arrangement where I can create this new legal entity that is my trust, and my trust can now own stuff. It's kind of like a business that's not a person, but can own things. Your personal trust, it's not a person, but it can own things. It can become the title owner of your assets. Um, and in that trust during your lifetime, because it's revocable, you're in total control of it. You can do whatever you want with the trust. You can change its terms. You can revoke it altogether and get rid of it. You can put your things into the trust, take things out. It doesn't really change your day-to-day at all. But it is a separate legal entity from you. And what that does in the event of your passing is it creates a different path for the administration of an estate, right? So
Mhm.
just quickly, like if I own my house and I don't do a trust, but I have a will, when I pass away, I already told you we got a practical problem because my name's still on the title of that house. And that's the practical problem that triggers the need for the court's involvement in probate. If I set up that same arrangement in a trust during my lifetime, my trust becomes the owner of my house. And my trust continues to exist even after I'm gone. And the trust has instructions to say, hey, when Andy's gone, here's who's in charge and here's exactly what needs to be done. And so we've created a new legal mechanism to administer my estate through my private trust administration. And we never have to go to the court to get that authority. We set up a different way to get it.
So hence you avoid probate.
Hence you avoid probate. That's right.
Yep. Yep. So it brings everything private. It's probably more efficient through the process. That probably costs less because you don't have all the time spent going through the probate court process. Those all pretty accurate statements.
It is, and it's much more efficient, not only in cost, but in time, because the trust administration can happen immediately, whereas starting the court process of probate involves typically hiring a lawyer, filing a petition, waiting for a hearing date, and weeks go by before you even have someone with authority to deal with the house. Contrasted with the trust, which the very next day after I pass away, that authority can be transferred and you can proceed.
So it's really about control and protection, isn't it?
This is about
Yeah.
control, protection, efficiency. Yeah, it's about a lot of things.
So getting back to trying to demystify the trust, it's an entity. You put the assets into it, change the ownership of that, and then you can avoid the probate process. And again, now what we're trying to do, a couple of reasons. We'll talk about the tax implications in a second, but also just from the perspective of protecting your family and that legacy that you're leaving behind. Typically less disagreements when things run smoothly. All the disagreements, and I've been doing this for a long time, Brian's been doing it for a long time, with all the disagreements, at least that I've seen over the years, really comes up when things drag on. It seems like that's a lot of them, not all of them, but a lot of them. So let's see if we can get to a spot where we can make this more efficient for your family. So if you are going to look at this page, again, we see a number of these documents from our clients, and I know, Andy, you draft these documents, but could you just kind of talk about the differences between these wills, trust, a healthcare directive, and the importance of that, especially maybe for young people as well, which people forget about from an estate planning perspective, and then the power of attorney.
Yeah, so when I look at this slide, I see each of these things as one of the elements of a complete estate plan. And they each play a different role, although they're related to one another. So on the right-hand side there, with healthcare directives and powers of attorney, I usually frame those as incapacity planning tools. And what I mean by that is those documents really don't have authority after someone passes away, but they are designed for the potential future situation where if someone's living, but they have lost the ability to make decisions about either their own, care, medical care, or about the, the ability to manage financial and property decision making. The healthcare directive is where you can nominate somebody to step in and be an advocate for you in a healthcare environment. And the power of attorney is the same, except in a financial environment. And so these two tools are potentially critically important if ever there's an incapacity. But then again, after someone passes away, they don't do anything anymore. And that's where we get more towards wills and trusts and the role that they play. These are a little bit more aimed at managing assets after someone passes away and directing where they're going to go, who's going to receive them, and under what terms. So these sort of fit together around, while you're alive and you're thinking clearly, you make all your own decisions. If you become incapacitated, we've got some plans for that. And in the event of someone's passing, we've got plans for that too.
Yeah, that makes a lot of sense. And sometimes what I come across is people don't quite understand how the power of attorney works. And I don't mean from the standpoint, they understand the mechanics of it, but they don't understand like when it doesn't work, maybe is a better way of putting it.
Right.
So I know you just talked about it, but could you make it clear? I mean, how does that power of attorney stop working?
Yeah, I get a phone call on that very topic at least quarterly, sometimes more often than that, where someone calls because they were always, named in mom's power of attorney and she passed away and they want to square up the bills, but they won't honor the power of attorney anymore. And it really is abrupt. And it is not, there's no question. When the creator of the power of attorney passes away, it no longer works immediately. So even this thing that you could have used for years to help an aging parent or something like that, as soon as they pass away, it doesn't work anymore. Common misunderstanding.
And we run into that sometimes. It's interesting. Then Brian and Michael, I know, can both speak to this. We'll run into this where maybe somebody that we've been working with, let's say it's a parent and an adult child, and that adult child is the POA, the power of attorney. And maybe for years we go on and talk about that, but then the parent passes and that POA is not necessarily the executor or the personal representative or the trustee, depending on the terminology. And that creates some confusion, maybe put it lightly. Brian, Michael, any thoughts along those lines?
I think that one too, Mike, but I think also I get a lot of husband and wives, married couples coming in. They think they already have power of attorney for each other just because they're married. And that's not true either, right, Andy?
That's right. That's right. You have to affirmatively name somebody. And usually spouses name each other, but they don't have to.
They don't have to, exactly.
Not automatic.
Yeah. And we do talk a lot. Yeah. When our kids go from 17 and 18, we say, hey, mom and dad, you're no longer, the guardian of this child. You really need to have a power of attorney and healthcare directive as we send them off to college, move out of state, get a job somewhere else. They have a car accident, they get into trouble, they're not going to be talking to you anymore because they're going to not look at you as, the power of attorney without that document.
Right.
Yeah, that healthcare directive, most people don't think about, right? For their college kid.
Yep. Unmarried child. Yep, exactly.
Yep.
So.
I gotta say, in the early throes of the pandemic, as parents were sending off their 18-year-olds to college, my clients, that happened a lot. I got requests from them because our minds are in this pandemic environment. And
Mhm.
they were asking, can we get this done for my kid before I go to college? And I've never had that before, and it's been less common since. That's a really good idea. It's a really relatively simple tool to prepare, and it could be really important.
Yeah. Yeah.
Yeah, I
Michael, did you
mean,
have something? Yep.
I was just going to add exactly what you were saying, Mike. I mean, the day that your child turns 18, if they went to the hospital for some reason, I mean, really, you don't have a legal right to get information from the doctors without a healthcare directive. And so maybe not the most exciting 18th birthday present. Maybe don't line it up with that day, but that's an important consideration.
Yep. I agree. You know, and there's nothing worse than a parent who can't get information about a child who's either sick or hurt because there's some paperwork not involved. You know, and so the healthcare directive is really important for that. Of course. Yep. Okay. So when we're looking at considering kind of real estate within a trust, because that's a whole nother nuance. One, we have to kind of get at least a valuation, or maybe not an appraisal, but a valuation on some of this, the real estate. But Andy, how about, what's maybe some best ways to handle real estate? And a lot of our clients have real estate in other states besides Minnesota. Could be Wisconsin or Iowa, but a lot of times, more and more, it's Arizona, Texas, Florida. So what should we be planning around from the real estate perspective and using trust for those?
Yeah, so there's a few different things I would say. One of them is when we're talking about the type of trust I mentioned earlier, the revocable living trust. Usually you want that when you center your estate plan in a trust, you want that to be kind of the clearinghouse for all your stuff. And that includes real estate. So certainly, your homestead, we're talking here in Minnesota. So, if you got your Minnesota homestead, that goes into your trust. But if you did own like vacation property or another piece of property in another state, you want that to be in that trust as well. And that's okay. You can take out-of-state property and put it into your Minnesota trust. We do that all the time. In the absence of that, if someone were to pass away, we already talked about, owning a house in your own name and how that triggers probate in Minnesota. But if you also own real estate in Wisconsin, you got a Wisconsin probate to deal with too. And if you have that vacation place in Florida, now you've got a third probate to deal with. And so the inefficiencies start to compound, or said in the reverse, the efficiencies of a trust start to add up.
Mm-hmm.
Um, So yeah, that's
Well,
kind of the main thing that I see most frequently when we're talking about real estate and trusts with estate planning, is that the value of a trust increases when we're talking about real estate in other places.
yeah, yeah. Especially when you get into potentially multiple probate processes that
Right.
take your numbers you were using earlier and inflate those by a 3x, and it kind of gives you what the cost could be to go through in different areas, isn't it?
Yeah,
Isn't that
it
the
can
case?
be. Yeah, it can be real
Yep.
clunky.
Yep. So real estate obviously is something that needs to be considered when you're doing your estate planning and has to go into the trust. And I'm going to let Michael talk a little bit about a kind of a case study, for a family with some assets in different areas that have done well for themselves. So, Michael, why don't you talk about this, and maybe some of our clients on this webinar can relate to this couple.
Absolutely. And this is the same couple that we had a brief glance at earlier. And it's a situation where, with some estate planning, we can have more effective management of their assets, reduce some tax implication and better financial outcomes. Without it, we see higher taxes, probate expenses, lower overall value of the estate going to the heirs because of that, and potentially more family conflicts. And so if we go to the next slide here, we've got Jane and Joe. And Jane has about 510,000 in her estate, Joe at 3.56 million. And right now they have no estate documents in place. And so there's really nothing that's been planned for them at all. And we're in the state of Minnesota. And Andy mentioned earlier that in the state of Minnesota, when you're above $3 million of your estate, you start to have some estate taxes come into play. And so upon Joe's death, however, and Andy could speak to this more thoroughly than I can, but we've got a full transfer of the estate to Jane, and that's without any estate taxes whatsoever, because it's a transfer to a spouse. in the state of Minnesota. However, now she's got a $4 million estate, which is more than 3 million. And upon her death, we would see potential taxes of, you can see it broken out on the right-hand side there. There's 135,000 estimated in Minnesota estate taxes. And then we put in a probate amount that's a little higher than the best case scenario Andy was mentioning, just because there isn't any guidance from even a will in this case. And then there's also this other tax, which is one that people don't often think about, but it's a income tax with respect to the decedent. And what that refers to is any IRA money that's inherited is going to have taxes paid for it when it's withdrawn from an inherited IRA. And so that's one where, I mean, we're not necessarily focusing on that specifically, but we like to quantify that to some level just so people understand when your IRA is passing on, there are going to be taxes paid over time for that. Now, if we go to the next slide, we can see with some of the estate planning techniques that Andy's been talking about, we could, and maybe I'll have Andy speak to the design of trusts that could accomplish this, but essentially we're looking at eliminating the probate expenses. We're looking at eliminating some Minnesota estate taxes. And so Andy, I'll turn it over to you to kind of talk through how they're able to accomplish that.
Yeah, so the underlying concept here is that this $3 million Minnesota exemption is actually a personal exemption to each person. So in a married couple, you have two of these potentially available to you. But in the absence of any particular estate planning, what happens by default is what you were just saying, Michael, which is on the first death, there's never an estate tax between spouses because there's an unlimited marital deduction to the estate tax. So for Jane and Joe here, on the first death, there's no estate taxes to worry about, no problem. But what we're left with then is one surviving spouse holding 100% of the assets. And on the subsequent second death, that's where we have the estate tax exposure. So just quickly in a nutshell, the way that you can do some trust-based estate planning to change that outcome is you can set up a framework where on the first death, the surviving spouse usually elects to set aside a piece of the estate into a separate trust share that benefits the survivor in almost every single way. The survivor still enjoys the income from that share and can, access the principal if it's needed for their care and support. But they let go of just enough of the strings of ownership of it for Minnesota Revenue and the IRS to look at that and say, all right, surviving spouse, sure, you get the income, sure, you can access the principal, but it's technically outside of your estate just enough so that it's not going to be included in your taxable estate. And therefore, that piece that's carved off on the first death can be sheltered by the spouse's tax shelter who passed away first. And it's a way to capture both spouses' estate tax exemptions. So that was just a lot of information in a tiny nutshell. I hope that made sense. But yeah, it does require proactive planning, I guess, is the message for today. You can't wait to try to pull this off after the fact. It has to be proactively put in place.
And so, oh, you can go ahead, Mike.
No, go ahead. Go ahead, Michael.
Yeah, so one other nuance for those of you that are watching really carefully, if you go back one slide, Mike, you'll notice that Jane's estate is only 510,000, and it actually increases when we move to the next slide. And that's because Joe is also the only one on their home right now. And so some of the planning is as simple as that, is let's equalize this estate value a little bit. And so that's something that's kind of happening in the background where maybe if you're a numbers person, you saw that difference, and I wanted to mention what that was.
Yeah, so it reduces Joe's estate. You shifted the asset over to Jane's estate, if you will. Therefore, to the point that Andy was making, each of them now get $3 million exclusion, and they would both take advantage of that and could all the way up to $6 million, and not really be overly concerned about paying estate taxes to the state of Minnesota and the Department of Revenue here. But maybe one of you guys could talk about that. How does that differ from the federal estate tax? I know this is a case about Minnesota, but federal estate tax has got a higher exemption amounts, but how does that work?
Yeah, so we talk about Minnesota first most frequently because it's the lower threshold. It's the first one we bumped into. But the federal estate tax at the moment, over $13 million, that's scheduled to repeal at the end of next year, which is still going to be a big number, but it's going to be cut in half. It's going to be closer to 7 million most likely, but we don't know the exact number because of the inflation adjustments. But that's why we talk mostly about the Minnesota number first. The other thing I guess that's important to note at this point is the rates of tax, because in Minnesota, the rate varies a little bit, but it's around 15% tax. If you bump into the federal number, it's 40%, right? So then it gets a little bit more serious. And I'm just noticing we did have one question from a participant regarding Wisconsin, and I'll just use this opportunity to say there is no state level estate tax in Wisconsin. I'm licensed to practice also in Wisconsin. And there's no Wisconsin estate tax. So it really does depend, on your situation and your specific facts. But in Minnesota, we talk about that number first because it's the lower threshold.
Yep.
But if you do bump into the federal one, it's a serious rate of tax and merits a real look. The other thing, Mike, I think you were getting at is this idea of what they call portability with an estate tax. So the federal law and the Minnesota law are different in this way. Federal law has a concept called portability where you don't have to do any affirmative estate tax planning from a federal perspective. And after the first death of two spouses, a surviving spouse can file a federal estate tax return to essentially claim the unused exemption of their spouse. And that can be done after the fact. They call that concept portability. Minnesota law does not afford you that opportunity. And so affirmative and proactive planning in Minnesota on this topic is really critical. I think that's what you were getting at, Mike.
That's exactly what I was getting at. And, because what also ends up happening is, over time, usually net worths will grow, and this becomes potentially a bigger and bigger problem somewhere down the road or for the next generation. Michael, do you want to talk about this particular slide?
Yeah, really what this is getting at, and this is something that I would just say for all of our clients, we start with, as Mike did at the beginning of the presentation, of what is your estate value today? But we don't stop there. We also want to look at knowing all of your needs for income and all of the contributions and, growth rates that are appropriate to your investments. What will your estate be in the future? Because sometimes even if you're not at a level where the trust planning seems as essential now, it could be coming soon. And the other thing that's not necessarily incorporated here is perhaps there's an inheritance that would be part of your estate in the future that you have not yet received. And so I think it's really important to be thinking through not just today, but looking into the future. And so, here is just an example of someone's estate today and then growing over time, again, a Minnesota resident, and those taxes and expenses can really start to add up, because if we're looking at that sort of 15% rate that Andy mentioned on a larger estate size, it becomes significant. And Andy, you could probably just speak to, if they put together that planning we were talking about on the last slide, how much would that usually cost, even on the high end of expenses?
Yeah, I mean, well, just looking at Joe and Jane, a cumulative $4 million estate, if there's no estate tax planning, again, no worries on the first death from an estate tax perspective. But then you've got $1 million being taxed at roughly 15%, which isn't nothing. That's $150,000 just like that. So, doing a little bit of proactive planning can give you a pretty quick return on the investment. And when I say the investment, of course, I'm just meaning time, effort, and cost to establish this kind of estate tax plan.
Yeah, what's interesting about this, and Brian, I'd love to have you give a little bit of an opinion. You look at these projections going out over a longer time period, and it's $1 million potentially is owed. Part of it can, of course, through good planning be covered, but maybe you just end up with more than the exemption amount. What might be a solution that we would consider for somebody in this case?
Yeah, I think we find a lot of times we're working with clients that have real estate and they think they're going to hold that real estate to death, and it's going to grow naturally behind the scenes. So maybe it's a commercial building, maybe it's a family farm. Michael and I were working on a client that had a collection of real estate business, and he was in his mid 40s, but we were talking about, well, your projected life expectancy is going to be mid 80s. And he was surprised how much his real estate holdings was going to grow throughout his lifetime, even though he was just going to collect the rent and keep the property for his family to inherit. So he was in a non-inheritable or non-estate tax situation here in Minnesota, but he was going to be one when he was in his mid-80s.
Yeah, yeah, and then we see that a lot, and sometimes when you bring up a good point, it's real estate. We see a lot of times family cabins, they want to keep that cabin, and there's 3 kids that are going to inherit that cabin. That's another webinar, how to handle that approach. But those cabins, that real estate, they're not liquid, so this check needs to be written somewhere along the line. From a liquidity standpoint, there's a couple ways you can pay. You can just drain out, some accounts, right? Or from a protection perspective, maybe looking at some sort of insurance that could cover that, for the beneficiaries, so they wouldn't have to start selling properties.
Yep, exactly.
So a couple of different things to take into consideration, but today's net worth certainly doesn't mean the same in 10 years or 20 years, especially with the power of compounding. In here, we're making some assumptions that assets are being spent and that sort of thing. But think about from the standpoint, if there isn't, and the money's doubling every, 10 years, because you're making 7% on it, how this problem can also compound for the beneficiaries.
Yep.
So, there's a number of different considerations. Maybe we can either any of us here, Michael, Andy, Brian, talk about maybe a few different strategies some people could take to minimize their taxes as much as possible. We've talked about trust. So, maybe when you look at those strategies around the beneficiaries, I'll talk about that a little. Every vision review, and for our clients, that's a meeting once or twice a year, in addition to their quarterly conversations that they have. But we go through and do a beneficiary review. One, because again, been doing this long enough, we know beneficiaries will sometimes change. 2, we want to make sure we have it right. And so remember, these assets that are named with beneficiaries are the ones that are going to go directly to those beneficiaries. And so if you have young kids, even young adult kids, you might want to think about, how do you set up your IRA accounts if Tommy is going to inherit my IRA? So God forbid something would happen, and at the age of 18, Tommy gets a big IRA account because he's hit the age of majority. Is that the best case scenario? But the strategy of realigning your beneficiaries and reviewing them every year is just something that we think is crucially important, and needs to be done, especially on your IRA accounts. Maybe one of you could talk a little bit about TOD or POD accounts, and how that's kind of the same as a strategy around beneficiaries.
Yeah, non-retirement accounts, you can add a payable on death or transfer on death, depending if it's a bank or an investment account, and that would be giving the bank or the investment company some instructions on who's going to take over this account after the owners are no longer there. So all the named owners have passed away. There's a mystery of who's going to inherit this. Well, in a non-IRA account, if we have a payable on death or transfer on death, there's no more mystery. So we don't have to go through the probate process to get those funds, moved into the right the beneficiary's ownership. So that's one strategy to do that if you're not going to change the ownership of that account into a trust. So that would be one way to work around it. If you didn't have a trust set up, at least have some transfer on death or payable on death instructions on those accounts. And that's a special, that's not a given. Like in IRAs and 401ks, that's a given that we have beneficiaries to be named. But if you open up a non-IRA account, unless you take that proactive approach, and that's something we do at 360 doing that review process, we're going to ask like, well, do you want to name somebody on this account? It's a mystery if something happens to you. You can do that also at your bank too, with larger checking accounts, larger savings accounts, things like that. So Andy, you want to talk about maybe transfer on death deeds? That's something I talk a lot about my clients that haven't done the work on a trust, but they think, well, I can just maybe work around that with my real estate using that tool.
I'm looking at the clock and I'm looking at this slide and I'm thinking of about 5 things I could tell you. But transfer on death deeds is basically, to put it succinctly, a way to put beneficiary designations on real estate. Yep. And that's a relatively new legal tool. And since 2008, it's been available, which is a while ago, but in the eyes of the law, that's pretty new. So yeah, it's just a way if you had one or two, adult mature beneficiaries that you wanted to receive real estate, you could consider that as a trust alternative, as a beneficiary designation for your real estate.
Good.
Mhm.
For our Wisconsin clients, does Wisconsin have transfer on death deeds?
They sure do. Yeah,
Okay,
do them all the time.
good.
Okay, good. Could you talk a little bit, Andy, just because I know we are closer to running out of time, but we're still good within the
Okay,
time
all
period
right.
of what we told people. But how about from if somebody sets up a TOD account and they have a will, what what might create a problem somewhere down the road? Or they have a trust for that matter.
Yeah. So wills and trusts don't care about your beneficiary designations. They don't talk to each other. So if you name person X as the beneficiary on any given account, but you've got a will or a trust that says person Y gets everything, person X is still going to get the accounts that they're named on, right? So the beneficiary designations really do they don't automatically coordinate with the rest of your plan. And when we're helping folks through an estate plan, we are making intentionally certain that you've got things the way you want them, including coordination of beneficiary designations along with your will or your trust, because they don't speak to each other. And then I guess one related thing is sometimes when someone does choose to use a trust as their estate plan, when you do that, you created a legal entity that can be named as a beneficiary. So you could do a transfer on death or a payable on death designation to the trust. So that, it's just a different way to set things up. I guess the point
Yep.
for today is you got to manually make sure those are well coordinated in order for your plan to go the way you want it to.
Absolutely, absolutely. Because I've seen the difference where it's not. Hey, Michael, could you speak a little bit about gifting and how that might help with this trust planning?
Absolutely. And so one of the things as we were looking at that slide where the estate's growing over time, one strategy would be, well, what if you remove some money out of the estate, and then all the future growth on that's going to be outside of your estate? A very common way to do that is to do annual gifts to children. Right now, the gift limit for this tax year is $18,000 per year, per spouse to any individual. And so if you had 3 kids, both you and your spouse could give them 18,000 each or 36,000 each. And we're looking at 108,000 that you could remove from your estate without having to dip into that estate tax exclusion amount. Now, technically, you could give amounts above and beyond this 18,000 per year, but then you start using your estate tax exemption, and there's some gift tax returns that you might need to file. And it's just a little bit more administratively complex, but that's certainly something that you could investigate as well.
And our partner here, Joe, and the Rapaki team over in Edina can go through, some projections on what that might look like from a tax standpoint for sure. And since you're on a roll there, Michael, how about maybe some of these ideas around some tax implications? As far as some strategies, RMDs, Roth conversions, anything there that you would commonly look at for a client?
Yeah, absolutely. In the case study slide we had earlier, there was that IRD tax, and that's taxes that your heirs are going to pay on their inherited IRA money. And so one of the things to really think through is, okay, so what tax bracket would we expect them to be in? What tax bracket are we in today? We could potentially convert some IRA money to a Roth IRA because Roth IRAs don't have that tax at all. Roth IRAs are inherited tax free, or federal income tax free, and state income tax free. Could technically be an estate tax. So I'm trying to be very, very clear on the tax implications to keep Andy happy.
Uh-huh.
But just thinking through, okay, does it make sense if we have a lot in IRAs to maybe position that so that our heirs receive more in Roth IRAs? If we're doing charitable giving after age 70 and a half, you can do qualified charitable distributions from those IRAs. And that's another way to reduce that IRA value, and maybe leave some to charity. Or maybe you have a charity as one of the percentages on your beneficiary designations. If you have a nonprofit or church or something else that's important, because that charity does not have to pay that IRD tax. And so there's a few different things to think about as far as how to set everything up and coordinate it to accomplish what you want to accomplish.
Yeah, that's so really what you see here is, I don't want to go to that yet. There's so many different considerations. Like Andy said, we could probably go on for another hour, with this slide, and that would be going way over our allotted time for this program. But that's why we encourage you to reach out to the professional that you're working with, that you trust, or with our team here at 360, or with Andy, or with our partners over at Rapaki and Company over in Edina, to kind of start managing this whole process for you and start making up some, some potential outcomes on how you want things to look. In other words, what do we have to consider? And so, we're really dedicated to this area because we think it's such an important aspect of wealth management that we are rolling out kind of a series of estate planning webinars. This was our very first one. And then we're going to do another program that's going to be just focused on blended families. And you might say, well, I don't have a blended family. My wife and I have, been married for 48 years. You probably have in-laws, son-in-laws, daughter-in-laws, and so we do have the blended families like I do, where my wife and I got remarried, second marriage, and we have kids from each family. Then there's some planning nuances around that are very, very important. And then we're going to have another program that's coming up. So November 12th is the next one before Thanksgiving, and then December the 3rd. That's really focused on, let's take the case study that Michael just did with Jane and Joe and expand it. How does this get even more complicated when the monies become bigger amounts? And a lot of times where we see this, of course, is in areas where there's a family business. The family business is almost always the biggest asset of a family. But it's also the most illiquid asset of a family typically as well. Family farms fall into this as a huge asset that's usually not very liquid. And so then families that have just done well for themselves as far as climbing the corporate ladder or other professional careers. So we've got 2 other programs coming up. We will make sure that you receive invitations for these other programs. And, at the end of the day, hopefully this hour has been time very well spent for you. We've got a few questions I'm going to kind of go through, and if there's any that the other professionals on this webinar have come across, let us know. But and we'll go through them here now. But it's really crucial if you're going to get a handle on this to do it now versus later. We never know when that time's going to happen.
Here's a great question that came in. How does your team recommend coordinating estate planners, financial advisors, tax professionals, and insurance providers? At times, it seems disjointed.
Okay. So would you like to address that, or would you like to, it typically is disjointed. So what's our approach?
Yeah, our approach, Mike mentioned some of the meetings we have with our clients regularly, which would be vision reviews and quarterly conversations. But in addition to that, we like to have joint meetings with other professionals. And so if we're talking about estate planning, let's have a joint meeting with everyone in the room. I think something that I see a lot of the times is that you end up sort of playing telephone with your different professionals. And they tell you something, and then you have to pass the message along, and maybe there's something lost in translation. And we want to avoid that type of situation. Let's just get everyone in the room, or everyone on the phone, or everyone on the Zoom, however we can do that at the same time, because that's just the most efficient way to make sure we're communicating well.
Yeah, it's just really a matter of somebody's got to lead this process and communicate with all the parties involved to make sure it moves along nicely. We've done this a lot. We can work with Andy, we can work with Joe, or whatever CPA or whatever attorney you want. But these guys on this call know what they're doing, and let's coordinate this and communicate very, very well between all of us to get to the outcome. And that is to protect the family, protect the legacy, and frankly, pay as little in taxes as you legally need to pay. That's our goal.
Yep. And I think adding the next generation too, as we get older and we're in our 70s and 80s, it's also good to bring in those adult children who are ever going to be your heirs into that meeting as well, so they know what's going on before before that happens. So
100% agree with that. I mean,
Yeah.
family meetings are just one we really enjoy doing them, but they end so much of the debate that happens later because everybody's together in that room talking about what mom and dad's wishes are, and and they sometimes, yeah, I know it's not the most comfortable topic in the world, but if you want to leave behind a positive legacy of really well planned estate, and make sure that the family has less complications to deal with, they're really crucial.
Yeah.
So, any other questions that maybe have come up? We are going to send out the webinar to everybody who registered for this, so you'll have a recording of it as well as a checklist to kind of go through, to at least try to give you some ideas of what area do you need help with, and then all of us, of course, are available to help afterwards too. I saw one question that came up. Maybe you guys have something, but how about just leaving what's it say here? I put my child's name on the deed. Is that a good strategy? I mean, that's basically what it says. So, Andy, you want that one?
I was gonna say, I've got a lot of responses to that. A lot of times people put, an adult child on the deed to the real estate, and the idea is oftentimes, well, then when I die and you're surviving, it'll go to you automatically without probate, and it is effective at that. But in doing that, you also invite some other considerations, which maybe are okay with you, but you shouldn't ignore them. For example, your child in that example is a co-owner of that property right then. And if they themselves get into financial trouble or are liable in a car accident and have a judgment against them, that property becomes available for those types of claims. And there are other tools available, including the transfer on death deed, that might accomplish probate avoidance and getting it to the right person without opening up some of those exposures that come with a joint ownership. And for today's purposes, I guess I probably should leave it at that, but it's a more nuanced conversation than just adding someone to the house. There's a few things to think through when you do that.
Yeah, and so sometimes what ends up happening with that is also you leave some tax benefits on the table too.
That's right. Yeah.
So again, another reason to address that and see if it makes sense to do something along those lines. Well, I think overall that this hour hopefully that has been well received. Thank you, Brian, for being on this, Michael for joining us, Andy for sharing your knowledge and your expertise in this area. And we will be sharing everybody's contact information so that we can be here as a resource and a team to anybody who needs this help.
Yeah, and then just a couple housekeeping items. We do have those other webinars coming up that we mentioned. And I think there's going to be an opportunity to give some feedback to this webinar. We welcome that feedback. We really want to provide great webinars that have helpful information. And if you've enjoyed this webinar, you'll get a link to the recording of it. Feel free to share that with others that might benefit from this information. We're very happy to have it shared freely so people can take advantage of it.
And you know what? Share it with your kids, so they kind of know what the process is and what you're going through. And I think it's an hour time well spent. It's a lot better than paging through Instagram or Facebook to learn a little bit how to save potentially a lot of headaches and a lot of money somewhere down the road. So the one thing we're going to cover, because there's a number of people on the webinar here that are clients, and so I'm going to dispense for whoever wants to stick around, just learn a little bit about the 360 way as far as how we work with our clients and go through this estate planning procedure and process, and spend about 5 to 6 minutes doing that. Or for the people who are clients, if you want to see it again, or you want to share it with your kids or your friends who might need some help in this area as our sounding board process, we're open to people contacting us, and we can help them, and that we can act as their sounding board. So I just want to make sure that none of you have seen any other questions pop up in the web the webinar here that we have not addressed?
Nope, I don't see.
Okay. So I'm going to go back into the sharing again, and we'll pull up the same page I was looking at, which is the scene that we have. So, for again, the group that doesn't know us, let me just go into kind of how we work. And I started the firm 30 years ago, and we've expanded over the years. Brian joined us a couple of years back, and the point of what we do here is really focus, whether it's Brian up in the Elk River office and his team, the Wayzata office and our team, or even when we're over at Joe's office, the Repacking Company's team in Edina, is we just want to make sure that we're focusing on what matters to you. It seems pretty simple, right? But as fiduciaries, because we are a registered investment advisory firm with the SEC, we'll want to focus on not only what's important to you, but how do we help you be good stewards of your finances? So we always are going to focus on these aspects that are most important to you. And we've narrowed that down into a way to gather and track it and benchmark it into an acronym called FORM. Are we talking to you about what matters mostly and what's most important to you and your family? Are we setting goals and benchmarking and figuring out what's most important to you in your occupation? And if that occupation is just, I want to know my work optional date where I no longer have to actually go to work, but I can elect if I want to, that's great. Sometimes this occupation goes into retirement, and it might be occupation around how do you want to give back to your community that's so important to you, that's given to you over the years. And then we also want to focus on the aspects of what is it that gives you some juice in the morning, that gets you excited, this recreation piece. More and more, it's pickleball. But in the past, a lot of times it's travel. I want to spend time with the grandkids. I want to give them experiences. And maybe I want to take everybody on a family trip to Hawaii to celebrate our 50th wedding anniversary. See how now that kind of blends in the family and into the travel recreation aspect. And then finally, we want to set goals around what makes the why the most important. How do we generate an investment strategy and a life wealth plan around the why? And then we'll look at the how. And the money is the one that's going to really drive these goals. So we're going to have life goals around money. We have to have investment strategies around money. We have to have distribution strategies around money and estate planning strategies around money, because we know this is kind of like the gas of the engine, and the why, the family, the occupation, and the recreation is really the important aspect of it. And then the money becomes the conduit. On the other side of what matters to you, we also have to focus on what we can control as part of our planning. So today we talked about some things that we can definitely control. You can pass away with a will or without a will. You have control over that. We also know there's a number of things we can't control. We're not certain whether Congress is going to pass laws to change or to not sunset these tax codes. We don't know who's going to win the election in November. So what we have to do is focus on what we can control. And we do that by focusing on our philosophy of how we work with our clients, our planning process, and what the outcome is, and the service promise that we make to our clients through a discovery, design, and deployment phase. And then we basically look at the process piece. So one thing I've done over the years, and Brian has as well, and we've meshed these together as we've worked together, is what's a process that can be repeatable, and that the next generation knows exactly what mom and dad were doing, and we can build that process for multiple generations. So we can control the areas that we control, and we can focus on what matters. The sweet spot here on the Venn diagram is where the life wealth plan, that's where 360, I think, exists. And that's what we bring to the planning relationship, because at the end of the day, what we're trying to do is solve for what's the most important to you, and using the money aspect to maneuver through these impactful financial events. We just talked about estate planning and legacy planning on the left. We also talk about investments, of course, with our clients, family security could mean a number of different things for a number of different families. Retirement planning, that could incur things like, do we save enough? Are we going to buy a vacation home? Where are we going to live? And a lot of times that goes right into Joe's group over in Edina and the tax planning, as well as the tax preparation of this. And then for our business owner clients, and we have a lot of them, how do we plan around that business owner? Does that go on business to other members of the family? Do you sell the business? Do you buy another business? And as you're growing your wealth and your legacy, those are all impactful financial events that really occur throughout the planning process. And kind of to your question earlier, Michael, where somebody said, how do you manage all this? Well, we manage it here by having a quarterly breakdown, and it doesn't necessarily follow this. It's just based on the priorities. We have quarterly breakdown of topics that need to be addressed with our clients through what we call our service promise, and that's either done through a quarterly conversation, which could be a phone call or a Zoom call, or it could be done through one of our vision review meetings, which is once or twice a year, depending on the client's needs and complexities. So we have a very well-defined process that kind of helps us go through, it dictates how we go through this planning aspect for you. We have an investment strategy process. And for time, I won't go through that, but it's based on a couple of factors. A foundational piece of really good, solid investments could be companies that pay dividends and they increase their dividends. And then we have a leadership approach, which is looking at different areas of the market and trying to figure out, as we heat map over here, where is the strength in different areas? Semiconductors is one, has been for a number of years, more recently popular, maybe home builders, maybe infrastructure. How could we take advantage of what's going on in the marketplace and layer that on top of our foundation of fixed income for some clients, depending on the risk tolerance. So we build this foundational and leadership approach and portfolio just really based on what makes the most sense for the client, not only from a risk perspective, but most importantly, how do they get to their goals based on the investment strategy helping drive it? So we've got this broken down into a 4-stage process. Typically, from beginning to end, you'll have a plan in place in about 5 to 6 weeks that will cover all these aspects of what we need to cover to try to get your estate plan in order and your life wealth plan up and running. So that's a brief overview. I've done a lot of talking here. Brian and Michael, anything that I missed that you might want to add on to that?
I think when you covered what we cover, so most time clients walk into my office, they're thinking about retirement planning, that one of those circles that was on that graphic, but we really try to go much more wider than that, like tax planning, estate planning, legacy planning, things like that. So I think that's something clients maybe are not thinking that they need that when they walk into my office, but they see the value after we talk about it and say, oh, that's my missing piece. I haven't heard anybody talk to me about those topics. So even like what we spent the last hour on estate planning, if that hasn't been addressed, it's going to leave a mess maybe for the family. So,
yeah. Anything, Michael, that you'd like to add? We still
Yeah,
have a number of people on, so they're interested in the topic, of course.
Yeah, I think I'd bring it back to that sort of core mission that we have here, which is to enrich the lives of our clients. And that's really what the form framework that we have is all about, understanding what do you value, and how can we give the best possible advice for you to use what resources you have to support those things that you really care about. And I think that that's just so ingrained in what we do here. I can nerd out about tax strategy and other things sometimes, but at the end of the day, I think what matters most for me and for the team here and for Mike and Brian and for our clients is that they're having a better and more enriched life by working through our process.
Yeah, the best compliment I get from somebody is, I don't worry about this. All right, that's our job. We get to worry about it. You get to go play golf. You get to go do the recreation activities that we laid out for you. You get to enjoy that travel budget that we put in the plan. So you actually go and guilt-free without any concerns. You go and spend the money on those trips if that's what's important to you. So, we hear that a lot. And the next thing I hear is I just want to make sure that my family's taken care of. And so by putting together this plan and making a hard copy of it and putting it into our binder and creating our life wealth organizer, it creates that what if binder for our clients that in case something would happen to them, that it's there to pull off the shelf, and the spouse or the kids know exactly where everything was supposed to go and where it's all located. So if you want to learn more about it, I mean, again, we do charge a fee. We can talk about how our fee schedule works. It's very competitive, but just give us a call. We'll schedule a 15-minute conversation. We'll talk about what your needs are if you're not a client of ours. And, or if you have some friends that you think could use our service, just the 15-minute conversation is just that, do what we do here and how we work, does it resonate with what you need? And if there's a match, then we can talk about how that works afterwards, and what the next steps are. And it's part of that life wealth process that I was talking about earlier. So we welcome conversation, and if there's something that we can do to help you, or you just want to jump on to a quick phone call and ask us a few questions after a follow-up to this webinar, we're available for that as well. So thank you again, you guys. Great meeting, great presentation. Really look forward to the one in November with the blended families, and then the other one in December. So thank you for everybody who's still on with us as well. And there's a number of you. Thank you for staying for this hour and 15 minutes. We really appreciate that. Andy, one more time, great job. We'll see you in November for the next segment.
That sounds good. I'll read the memo about the neckties next time. Sorry about that.
Yeah, that's another webinar. We'll talk about that later, but thank you, everybody. Really appreciate it.
Thank y'all.
Thank you.
Bye.